Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hey, Pam.
So we've recently come out of yet another election season, and it seems like we're in a permanent election mode. One of the things we saw is a lot of close elections, and obviously in close elections, who votes makes a huge difference. We also saw something else really interesting in this election, which was on the ballot in Florida, a ballot initiative measure passed that would re-enfranchise people who've been convicted of crimes in the past. And this issue of offender enfranchisement and disenfranchisement has been an important question in American law, at least since the 2000 election, where we learned that the margin of victory in Florida was quite small, and several 100,000 people were disenfranchised because of conviction for prior crimes.
That's right, Pam. And not only do we have issues with respect to disenfranchisement and reenfranchisement of individuals convicted of certain crimes, we have a second class of issues with respect to elections about how accessible we make voting for the disabled. And of course, there are a lot of individuals, citizens, depending on how you draw the lines, that are going to fall into the category of disabled.
That's right. I mean, it turns out that when you count all the different kinds of disabilities people have that might affect their ability to participate in an election, an astonishingly high percentage of Americans may be affected either now or in the future by problems that make it difficult for them to get to the polls, cast a ballot, and have that ballot counted.
So today, we've got two terrific guests with us. The first, Pam, is you.
Well, I'm just glad to be back.
Because as our readers know, Pam has played a leading role in shaping and writing about voting rights in this country in both areas we're talking about, enfranchisement and making voting accessible to the disabled.
That's true, but we actually have somebody here who's an even better guest and a rarer guest on the show, and that's our colleague Rabia Belt, who's a professor of law here at Stanford who specializes in disability rights with a particular focus on voting rights as well. She received both a JD and a PhD from the University of Michigan. She's on the president's Council on Disability, an appointee, I should say, of the prior president, President Obama, and she's really an expert on these issues. She's written about them from the time of the Civil War forward, and just, to pitch her work to you, if you're interested in this, you should Google her and read her stuff because it's just fantastic.
Well,
thank you so much, Pam.
I want to second that, Rabia. Welcome to the show. And why don't we start with looking at what most people think is a big issue, and it is a huge issue, which is voter disenfranchisement and reenfranchisement after conviction. And take us to where the state of play is. Maybe start with Florida. I don't know if we can go all the way back to the Civil War, but start us off, if you will.
Sure. Thank you so much for having me here to talk about this important issue. I am not even going to start with Florida or the Civil War. I'll start with ancient Greece and Rome, because the disenfranchisement of people who have been convicted of a crime goes back that far, where people who were seen as if they defamed society, that they broke some type of social contract, they lost the right to participate politically afterwards. In the United States, if we zoom forwards a little bit, this was not as much of an issue during early America because we didn't put a lot of people in prison. But this became more of an issue after the Civil War. And the reason why was because of the issue of what to do with people who were formerly enslaved. So that there was an influx, an increase of laws that criminalized all sorts of activity, and this activity was targeted towards African Americans.
So what you're kind of saying is that they used the criminal law as an excuse to get people off the voting rolls who they used to just exclude because they were black.
Exactly. And this was targeted in pretty nefarious ways. So, for instance, in terms of the activities that were criminalized, they were activities that did target African Americans. So, for instance, chicken stealing became a felony, whereas other things, stealing a considerable amount of money, may not be something that you would lose your right to vote.
The one I liked best about that, you probably know about this, is the 1901 Constitutional Convention in Alabama. They came up with a list of misdemeanors that would lead to your being disenfranchised. And the guy who proposed the list got up on the floor of the assembly and said things like, well, here are the crimes black people commit, and he didn't use the word black, but here are the crimes that black people commit. Here are the crimes that white people commit. Let's just use a list of the crimes that black people commit. So, for example, manslaughter they thought of as a manly Anglo-Saxon offense. So that didn't disenfranchise you. But bigamy, which they thought was something that black people did a lot of, that would disenfranchise you. And it took actually until 1985 before the U.S. Supreme Court said that law was unconstitutional.
Right. So Alabama was pretty obvious in terms of what they were doing, which made it something that was susceptible to court challenge, so that their laws could be struck down. But we still have the vestiges of that system today, where 5 to 6 million people are denied the right to vote because of a previous felony conviction, and race matters here. So this amounts to 1 out of every 40 adults that are disenfranchised, but 1 out of every 13 adult African Americans are disenfranchised. And in what used to be 4 states, but is now 3 because Florida is now off the list, more than 1 in 5 adult African Americans is disenfranchised.
And if I could stop you there for a second, different states seem to have different kinds of rules. So, for example, in California, if you're in jail, you can't vote. But once you get out and you've finished your sentence, you can. And Florida was one of the states that was lifetime disenfranchisement for everybody convicted of a crime, whether you ever went to jail or not, right?
Right. So there were 3 states, Iowa, Kentucky, and Florida, that had a lifetime ban on being able to vote after you were convicted of a felony. Now it's just Iowa and Kentucky. But yes, as you said, Pam, states do vary considerably in terms of the restrictions they have on people voting. So every state, with the exception of Maine and Vermont, does not allow people who are in jail of a felony to be able to vote. But then some states allow you to be able to vote once you are released from prison. Other states do it at the end of probation. Some states do it after the end of parole.
So other countries, is my understanding, often allow you to vote while in prison. So if we look at the kind of the big picture and draw it outside of us, I know Canada, I believe, does that. And a lot of European countries follow, I guess, the lead of a few of our states, Maine and maybe Vermont's the other one, and treat enfranchisement as something apart from punishment, I suppose.
Right. So the United States is not just an outlier in terms of how many people we incarcerate, but also in terms of the effects of incarceration afterwards. So in Europe, there's a movement towards suffrage. There was a 2005 case, Hearst versus the United Kingdom. The European Court of Human Rights found that the general rules for automatic disenfranchisement based on conviction is a human rights violation based on the European Convention of Human Rights. Also, as you said, Canada allows inmates to vote, and many other countries do as well.
This is Stanford Legal. And today we're talking with our colleague Rabia Belt about disenfranchisement. Right now, the disenfranchisement as a matter of law of people convicted of offenses. And I wanted to just, if I can, ask you one question, Rabia, which has fascinated me for a while, and I wonder if you have a speculation about this. And that is, there was an attack on Florida's lifetime felon disenfranchisement statute brought by the League of Women Voters about a decade ago, and it failed in the courts. And now we have a ballot proposition voted on by the voters, and obviously not by the voters, not by potential voters who've been convicted of crime, but people who haven't been convicted of crimes, re-enfranchising people. And usually the story in America is the courts protect the rights of those who can't participate in the political system, and politics is the problem. But here it turned out politics was the solution, and the courts weren't very interested. Do you have any kind of idea what accounts for that?
Well, I think part of it was the type of strategy that the advocates employed. So one thing is that they muted the conversation about race. So they had people who were coming from the Black Florida community that talked about sort of what was going on in terms of African Americans were disenfranchised, but that was not something that they foregrounded. They also had people who were white that had been convicted and then disenfranchised. So they did not talk really sort of leading about race, even though a lot of advocates around the country do that, but that wasn't the case in Florida. And they also muted the partisanship aspect of it. So it didn't become a Republican or Democratic conversation. Instead, I think it became a conversation about morality or a sense of community, where we recognize that people had screwed up. They got convicted. They were punished, but we should welcome them back, and they should become Floridians again.
What did the opponents say, Rabia? Because we're using language like welcoming back, and you screwed up, and we're forgiving you. And of course, you've already served your time, so to speak. But there must have been another side to that. What were the arguments that they used?
Well, I think this was another reason why the Florida advocates were successful, is because they cut off some of the most potent arguments that the opponents had. One thing is that even with this initiative in Florida, people who have been convicted of murder or sexual offenses are not able to benefit from it. So the opponents would try to talk about the worst of the worst in terms of the people who had been convicted of crime. So it was easy then for the advocates to do the rejoinders. No, we're not talking about those folks. We're talking about other types of people who have been convicted of crime. And I think that they tried to really sort of emphasize sort of the acts that people had done beforehand, tried to really have it as that if you had committed a crime, then you had a permanent forfeiture, that you no longer became a citizen. But it didn't seem as if that was something that really caught on to the Florida voters.
So in some states, I mean, one of the other places where we saw offender reenfranchisement play out was in Virginia. And there was a huge partisan overlay on the process because it wasn't automatic restoration, right? I mean, there's some things you can automatically do once you leave prison. You can automatically go to a restaurant and order whatever food you want to eat. You don't have to eat what they serve you anymore. But for a lot of people who get released from prison or who finish a term of probation or parole, in order for them to get reenfranchised, they have to do a lot of stuff. What's the evidence out there about how many of the former offenders actually managed to get on the rolls and then managed to cast ballots?
That is a really good question. So I don't really have the numbers in terms of the success stories. I mean, I know that with respect to Virginia, and then in other places, Kentucky has the same thing, where there's been a partisan ping pong match in terms of people who have been trying to get their rights restored. And I know that there is certainly evidence in terms of people who have had the right to vote restored, talk about how important it is to them. But it would be interesting to see the evidence. Pam, I don't know if you can sort of fill us in terms of the information on how many people, once their rights are restored, actually then do vote.
So it turns out, as far as I know, I mean, there's been a little bit of work done by Chris Uggan and Jeff Manza, who are probably the leading experts on the empirics of this. And what they say is that the best predictor of whether somebody's going to vote again after they leave is first, were they registered before?
That makes sense.
And the interesting thing is, for a lot of these folks, they weren't registered before because crime is so much of a young person's game, and people tend not to register. A lot of people don't register when they're 18. So if you go into jail when you're 18 or 19 or 20, you probably weren't registered ahead of time. And then the question is what your socioeconomic status generally is. So that determines, the kind of crimes that people commit are often related to the kind of socioeconomic status they're in. And so I think what they were estimating was that overall, only about 15 to 20% of ex-offenders, if they were re-enfranchised, would cast ballots, because that's about the baseline measure for people who are similar to former offenders, but for the fact that there's a conviction or not. And I should say here that this is Stanford Legal, and today we're talking with Rabia Belt, our colleague, about disenfranchisement in this first part of our program, talking about disenfranchisement of people convicted of crimes. Joe?
Well, you just mentioned, Pam, that maybe 15 or 20% of this group will vote. A low percentage, but to get back to the partisanship issue, a big effect on a lot of elections. I mean, if Florida had 15% of 1 million plus individuals voting, that could swing elections. And I'm guessing that the expectation is in most places this vote is going to go Democratic.
Right. So in most of the places where there has been this partisan ping pong match that's happened in Florida and Virginia and Kentucky and other states, it has been Democrats versus Republicans, Democratic governors moving to enfranchise, Republican governors moving to disenfranchise. I think part of it is that in terms of the actual number of people that are going to vote after their rights are restored, I'm not surprised that it's such a small percentage. But I think there's also an important signaling function that happens here, which I think is part of the long history of why we disenfranchise this group of people. It's supposed to signal that you are a second-class citizen because you broke the social contract. So to make the message, and Florida voters did so, that we're going to welcome these people back, that they are part of the community again, may have important effects aside from what type of politician gets voted in or out, depending upon sort of that subset of that group of people voting.
And just one other story from the 2000 election in Florida, which is the decision to disenfranchise people based on a criminal conviction requires the government to figure out who those people are.
Yes.
And one of the stunning things in Florida was the number of mistakes they made in 2000. That is, they saw some guy named John Smith, and they said, oh, John Smith was convicted of robbery. And they just knocked some John Smith off the polls. And it turned out that thousands of people who got knocked off the voting rolls because of criminal convictions were not the person who had received the criminal conviction.
Right.
And that made a difference in the election as well, because those people's ballots didn't get counted. So there's that sort of secondary cost as well.
Well, one of the takeaways from this for me, Robbie, is your last statement that this isn't just about who wins or loses. It's about the morality and the symbolism of, are you welcome back into the community? Is there anything you can do to get back into the community? And what our notions of community are.
And speaking of welcome back, we'll be back with more from our guest Rabia Belt talking about disenfranchisement and voting in communities next on Stanford Legal on Sirius XM Insight 121. Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman, and today we're talking with our colleague Rabia Belt about disenfranchisement, enfranchisement, and the right to vote. Joe?
Yeah. Rabia, we just talked about whether someone who commits a felony or a specified crime is going to lose the right to vote, and if so, when and if he or she can regain it. There's another class of individuals you study, and that's people with disabilities. And that's a big issue, isn't it?
It is. So the scholars estimate that up to 35% of voters over the next 25 years will need some type of accommodation at the polls. And people with disabilities are our largest minority group in the United States. It encompasses people that are blind, people who have post-traumatic stress disorder, who may have mobility issues, may have trouble holding a pen, all sorts of folks.
Can you give us some examples of what issues come up?
Sure. So I have an example of someone that actually embodies several different issues facing potential voters with disabilities. So Jack Vale is a young person who lives in Oakland. He has cerebral palsy. He doesn't walk or speak. He communicates through an electronic keyboard. And when he was in high school, his high school teacher gave him a research assignment to designate his favorite political candidate and who we should vote for. Became a big Bernie Sanders enthusiast. The wrinkle, though, was that his parents became his legal guardians when he turned 18, and that triggered his loss of the right to vote. So he basically became an adult and lost one of the most important aspects of adulthood.
Because he was under guardianship.
Because he was under guardianship. His dad, Lou Vail, got a notice in the mail that a judge had rescinded Jack's voting rights because of the guardianship. And he had Jack do his primary ballot by mail anyway, even though he knew that he wasn't going to be able to vote. His vote wouldn't count because he didn't have the heart to tell him that he had lost the right to vote.
Robbie, everybody that's listening is going to say, well, that's just wrong. What were they thinking? Help us understand how this could be.
Well, the majority of states disenfranchise people based on mental status, and this varies. So it can be based on whether or not someone is under guardianship, which is what the regulation that ensnared Jack. It could be if a court determines that someone is not considered to be mentally competent to vote. And then there's other states, 7 states, that still use language from the 1800s, the time period that I mostly study, language that we mostly don't hear anymore in conversation, like idiots or insane people. But that was the law of the land in the majority of states in the U.S. in the 1800s, that they used this language to disenfranchise people that were not deemed to be mentally competent to vote.
I mean, one of the things I found really interesting, I did an empirical study with a bunch of gerontologists and neurologists of people who live in long-term care facilities near Philadelphia. And we asked the directors of programming and services at these places, what's going to happen in the next election? And I think it was a very highly contested mayoral race. And some of them said, we help everybody in the facility to vote. And others of them said, we're not going to help people by getting them ballots or transporting them to the polls, or unless we're convinced that they understand the issues in the election really well. And of course, that latter category might knock out huge numbers of voters. And the former category, where they requested ballots for everybody without talking to them first, might lead to questions about whether people are under too much influence by somebody else. I mean, the idea is you should be casting a secret ballot. But that causes all sorts of problems for people with physical disabilities, doesn't it?
Right. This is becoming a big issue in terms of third parties who influence or affect the vote of people with disabilities, either for benevolent reasons, so people who are not receiving the accommodations that they need, so someone else says, I'll fill out your ballot for you if you can't use a pen. But then there's other times, especially in institutions, where administrators or staff people decide who are the members of the institution, the residents of the institution, that qualify to be able to vote. And those are the only people that receive a ballot.
So this is Stanford Legal, and today we're talking with Robbie Belt, our colleague at the law school, about disenfranchisement, and in this segment about disenfranchisement of people with disabilities.
And I'm thinking in that last thing you said, Pam, we're looking at long-term care. Everybody has an older relative, and some of us have almost become that older relative. And how often have we heard a statement like, Grandpa wants to live long enough to cast a vote against the Republicans or against the Democrats? That's what we know he would have wanted the most. And if he can't do it, we're going to help him with that.
Well, one of the things that fascinated me about this was, first of all, Jimmy Carter, after he became president, he wrote a book of really bad poems. And one of the poems is about casting votes on behalf of your dead relatives, that you should be able to vote for them for another couple of election cycles because you know what they would want.
I love you read the Jimmy Carter's book of poems.
That's the only poem I read, and it has some interesting rhymes in it. But there is this question that fascinated me, which is when I first started getting involved in these issues of people with cognitive impairments and voting, I went to a meeting, and it was mostly doctors there and gerontologists, neurologists, psychiatric social workers, and the like. And all of them said, oh, yeah, well, the guardian should just cast the vote the way they know the person would want it done, because that's what they do in all these other areas, like if you get stock certificates or your bank account. And I gasped, and I said, oh, my God, don't advise them to do this. It's a federal felony to cast a ballot for somebody else. And they were shocked because they say, well, of course, your children make your medical decisions for you. Your financial advisor makes these financial decisions. Why shouldn't people be able to vote? Is there something different about voting and people with disabilities than other things that people with disabilities might want to do and need assistance for?
Well, one thing that's happening, thankfully, is that we're moving away from a large-scale idea of guardianship writ large. So disability advocates push for supported decision-making so that the decisions are not taken away from the person with the disability. Instead, the able-bodied or able-minded person helps them.
Can I ask you a question about something else about this that interests me, which is as we change the way we do voting, it almost raises new problems for people with disabilities. Right. So Oregon went to everybody votes only by mail. Can you talk a little bit about the difficulties that something like vote only by mail, which is thought of as a big reform, or internet voting, which is thought of as a potential reform, what the prospects for people with disabilities are under those circumstances?
Right. This is one thing that I really worry about, because one of the things that becomes one of the rejoinders about concerns about accommodations at the polling place is, oh, we'll just do absentee ballots, or we'll just have mail-in ballots. This could be useful. So, for instance, with people who have cognitive disabilities or intellectual disabilities, it may give them more time under less pressure to be able to fill out their ballot. And in general, it's probably easier to do it when you're sitting at your kitchen table versus being in a polling place. The problem is, though, that these third-party people that we're talking about before, the influencers, they can have free reign, and it may be difficult to sort of pull away from it. It's also been an issue in funding. So, for instance, Lisa Schur, who's been doing a lot of the studies at Rutgers with respect to voters with disabilities, she was not funded for the 2016 round. She was in 2012, and she was told, well, mail-in ballots will solve this problem.
So you've been listening to Stanford Legal, and we've looked at something most of us take for granted, the right to vote. But it's actually more complicated than we think. We've got an issue with respect to people convicted of a crime. Do they lose their right to vote while in prison, while on parole, or forever? And we've seen the move that our guests have described away from losing it forever to losing it only while you're incarcerated. And then we've got these other issues with respect to how difficult voting can be and whether you could be assisted in voting. And maybe something for our listeners to take home is what would they want done with themselves when they get to that age that they need assistance?
Well, thank you so much for joining us today here on Stanford Legal, here on Sirius XM Insight 121.